Good morning from Singapore to all our speakers and guests today who are joining us from different time zones and parts of the world. My name is Christian Hoffmann. I'm an associate professor at the National University of Singapore and the deputy director of the Center for Asian Legal Studies, or CALS, as we internally call it. On behalf of the Center, I'm pleased to welcome you all to this virtual roundtable on Asian law. Today, we will be discussing a newly published book titled Court on Trial, a data-driven account of the Supreme Court in India. Today's roundtable is actually the 23rd virtual roundtable. CALS has created this virtual roundtable series to provide a platform for the discussion of legal developments in Asia and legal scholarship about Asia. It was launched in 2020 in response to the COVID-19 pandemic and the disruption to in-person meetings that the pandemic caused. I'm very pleased to say that since then, the series has been able to bring together a variety of different scholars and practitioners to engage in the discussion of a diverse range of topics. It has thus become an important platform for CALS to share ideas and new scholarship. We've kept this online format because it allows us to complement our in-person events in Singapore by inviting speakers and participants from around the world to join us for discussions of topics of Asian law without physically making their way to Singapore. And I would like to mention that one of our speakers today formed part of our very first virtual roundtable, which we held on the 27th of May 2020, Professor Aparna Chandra. Welcome back, and thank you very much for showing such strong support for our roundtable series. Professor Chandra from the National Law School of India is one of the authors of the book that we are discussing today. She's joined by the other two authors, Professor Sital Kalantry from Seattle University and Professor William Hubbard from the University of Chicago Law School. Professors Kalantry and Hubbard, a very welcome to you, and thank you for joining us today. Before I hand over to my CALS colleague, Dr. Raeesa Vakil, will guide us through today's roundtable as chair and moderator, I would like to say a few introductory words about the book, which we're discussing today, the book Court on Trial, a data-driven account of the Supreme Court of India. The book was published just a few months ago with Penguin India. It made it to the shelves in July 2023. The book builds on a decade of empirical research about the Indian Supreme Court. It documents the court's processes and procedures and makes a series of recommendations for reforming how the court administers justice. The authors read thousands of Supreme Court judgments and created a data set from scratch, while also relying on existing limited data sets about aspects of the court's functioning. One of the important realities forming the background of the book is the fact that the Supreme Court of India has frequently been criticized for long delays in deciding cases and for its tremendous backlog of pending matters. The book directly addresses these issues and examines judicial appointments, the assignment of cases to benches, and how representation by senior advocates affects admissions and accessibility to justice. But all of that, of course, will be explained in much more details by the authors. I'd also like to express my gratitude to our panelists who will provide comments on the book and engage in further discussions on its topics. As panelists, we have Professor Ronojoy from the Institute of South Asian Studies here at the National University of Singapore, Professor Marva from Lahore University of Management Sciences in Pakistan, and Professor Dinesha Samararatne from the University of Colombo in Sri Lanka. Again, thank you all very much for making today's roundtable possible. And with this, I'm now handing over to my colleague, Dr. Raeesa Vakil.
Thank you, Christian, and welcome to all our participants, the authors and our panelists. We're really pleased to have you all here today, and we know it's been a little difficult scheduling across multiple time zones, so we're very grateful to you for making the time to be with us for this discussion. We did send out flyers with detailed bios, so I'm not going to hold you very long while I introduce everyone. I know we're all keen to get to the discussion on the book itself. So I'll just say a brief word about each of our panelists, and then we can start the conversation right away. Professor Aparna Chandra teaches at the National Law School of India in Bangalore. She's a constitutional lawyer. She writes about Indian constitutional law as well as on constitutional law and matters of judicial review, human rights, gender, and the law, and currently on judicial process reform as well. She's also done a lot of work consulting with the Union Government of India and working on a number of very important and significant law reform projects. We're very happy to have her here today. Professor Sital Kalantry from the Seattle University is a professor, associate dean, and founder of the India Center there. She has extensive experience in litigation and practice and also teaches comparative law, business, and human rights, as well as feminist legal theory and contract law. She's widely published both academically as well as in media publications such as the New York Times. And also, we're delighted to have you here with us today to speak about your work on this book. Professor William Hubbard from the University of Chicago Law School visited CALS briefly quite recently. We're very happy to welcome you back virtually this time. He's the Deputy Dean and Professor of Law at the University of Chicago Law School. After a career in practice, he has moved to academia. His current research focuses on the economic analysis of litigation, courts, and civil procedure. He's widely published in this field, and he's also a research professor at the American Bar Foundation. Joining them, we have a set of panelists from across South Asia, and I'm very pleased that they've been able to join us so we can actually have a comparative context to this conversation that we're having today. From NUS, we have Professor Ronojoy joining us. He recently published a book on the Indian Parliament, which is a great companion volume if you're interested in looking at this book in context of Indian institutions. He's a senior research fellow and research lead for politics, society, and governance at the Institute of South Asian Studies and the South Asian Studies program here at NUS. He's published again quite widely in addition on matters of the Indian Supreme Court, religion and secularism, as well as a history of sport in India. Welcome, Professor Sen. From Pakistan, we have Professor Marva Khan. Thank you for joining us. Professor Khan is a professor at the Lahore University of Management Sciences. She's co-editor of their law journal and co-founder of the Pakistani Feminist Judgments Project. Her areas of research are constitutional law, human rights, and gender. And she's published as well on disability rights and accessibility in Pakistan, as well as on special courts. And finally, we have Professor Dinesha Samararatne joining us from Sri Lanka. She's a professor at the Department of Public Law and International Law at the Faculty of Law in the University of Colombo. She's published on matters of judicial review, public participation in constitution making, constitutional resilience, and this year she was appointed as an independent expert to the Constitutional Council of Sri Lanka. Thank you all for joining us, and I'll just briefly lay out the format of the event as we go forward. We'll have the authors of the book speaking for about 20 minutes, followed by interventions from each of our commentators for 10 minutes. And that leaves us with about 30 minutes for you to respond to the comments as well as to take Q&A. For those of you who are participating, please feel free to drop your questions in the Q&A box, and I will read them out to our participants for a response once we start. So please, we're looking forward to your comments. Please go right ahead.
Thank you so much, Dr. Vakil, and really thank you to the Center of Asian Legal Studies, Professor Hoffman, and all the remarks to come from Dr. Say and Dr. Khan, Professor Samararatne. We're really grateful for this opportunity to be here with you across continents and across South Asia. So what I will do is just start with introduction, methodology, and make a couple of points, and then turn it over to my colleagues to speak for 7 minutes each as well. So this collaborative project between us from Chicago and Seattle and initially at Cornell and Bangalore began with one of my colleagues when I was at Cornell, who's really the known as the grandfather of empirical legal studies. He might have been doing this well before, with great respect to University of Chicago, anybody at Chicago was doing it, maybe even before any of them were born. So he approached me and said, look, I've mapped all these courts around the world, Taiwan, Israel, and so much is such an important court, but so little is known about it, at least from an empirical perspective. And with that, we began this project, and of course, as you all know, right, nearly 20% of the world's people live under its jurisdiction, yet globally, not enough empirical work is done. Of course, some great work has been done in the last several years, which we rely on and cite. And the reality is that very little is also known in India. While Supreme Court decisions regularly appear on the pages of Indian papers, the institutional workings are largely not accessible to the popular audience, other than people who argue before it and scholars like Aparna who study it. And moreover, I think our unique contribution of this work is that we opened up what was previously a black box and exposed the interinstitutional workings of the court through sophisticated data sets and empirical methodologies, thanks to expertise of Professor Hubbard. We used several, over the course of 10 years, we mined several different data sets. One of them looked at basically 1 million cases, scraping cases from the court's website, and a textual reading of 5,000 cases that were hand-coded under our supervision by students all over in India and the United States, as well as looking at biographical data of basically every Indian Supreme Court justice ever to have sat, as well as high court justices, and then finally data and senior advocates and how their cases go. So the way we'll structure our comments today is really to talk about how, even though this court, was founded nearly 75 years ago, there's been little serious reflection over whether the institutional processes are working for it today in modern India, right? Unlike the Indian Constitution, which is perhaps one of the longest and most amended in the world, the institutional blueprint of the Supreme Court has largely remained stable over its history. Yes, the number of judges have increased. Yes, maybe certain procedures have changed, particularly, the appointments procedure, but not serious reflection has gone into how the modern trends of India might call into question the old institutional practices, right? As we all know, the backlog didn't come out of nowhere. It's that there was a litigation explosion. So more people are bringing cases. Certain lawyers play an outsized role. The life expectancy of judges has increased in the face of a mandatory retirement age of 65. And all of these changes that have happened in modern India call into question the current policies and whether the current trajectories are sustainable. So our book just it highlights some of these concerns and problems and opens up a conversation about them. And we hope this will be a wider conversation. It's already started, I think, across India, and we hope that it continues. So in many ways, the court's policies are in inherent contradictions with each other, right? So put it in other ways, they're working at cross purposes. And some of the trends that have happened in modern India have highlighted how these highlighted these contradictions. So I'll focus on a few of these points before I turn it over, right? So first, a mandatory retirement age of 65 was adopted in the Constitution, and that was nearly 75 years ago, when the life expectancy of people was around 50, and now it's around 70, right? So as judges, so today, as opposed to judges 75 years ago, have a longer life to live after they retire. and they need to seek employment to support themselves. So a great, article by Anay Dam and Co. have raised concerns of pandering of Supreme Court judges to their next employer, which often has been the government, though the trends are changing with private arbitration. But this mandatory retirement age, which now is young in light of today's trends, seems to be working in cross purposes with another important goal of any court, which is judicial independence. Secondly, another trend we have observed is that when we moved from a system of executive appointment to a collegium, the age of appointment of judges is increased. So while the age of appointment is increased and the life they live after they retire has also increased, they spend less time on the court than they did in the past. Effectively, the modern judge, the last 2 decades, spends less than 5 years in the court. And even this system is oddly shorter than the term limits of most Commonwealth courts. So if we were thinking about this today, we might say, okay, let's, we want, for whatever reason, we want judges to have a shorter period of time. We want changes, we want rotation, but we might have thought, well, let's do a 7-year term limit, which maybe is more the norm in Commonwealth countries. And just another sort of stark statistic, right? The short period of time is also seen, the short tenure is also seen in chief justices, and largely even more stark because from 2014 to 2022, the average chief justice of India spent 8 months at the helm of the court. And this, along with the short tenure of judges, leads to a significant amount of institutional instability as well as precedential instability, to the extent it exists, right, the precedential stability. So those are sort of 2 ways that old policies and new trends create call into question whether we need to be rethinking some of these policies. The final thing I'll focus on is the collegium system, right? It's a unique system. It's effectively a system where the Chief Justice of India, along with 4 senior judges, nominate judges to people to the Supreme Court, as well as the High Court, but we won't focus on that part of it, it's just focusing on the Supreme Court. This was created effectively by the court in reinterpreting the Constitution under these a certain group of cases. And in 1991, they felt that certain actions of the government was impeding on their independence, thus the need to be insulated from political appointments. But this quest for independence, which is a really important decision, right, for the future of a democracy, who the judges are, has seen clearly concerns, because many these decisions are made in secrecy, unlike politicization or judicial commission or political appointments like in the U.S. And as a result, in some cases, there might be favoritism, nepotism, or grudges, right, that prevent people from being nominated or not nominated, and those we're not able to even critique them because we don't have a whole lot of information about why someone is selected or not selected. And the other consequence of this collegium, which was meant itself to insulate the court from day-to-day politics, is maybe that it's maybe too insulated, right? So in our analysis of looking at different ways in which we imagine diversity, we found that while regional and religious diversity is inherent in appointments made by the collegium, the other forms of diversity like gender or diversity in terms of traditionally oppressed classes has not kept up, A, with the population of India, but B, also with with the ways in which the Parliament or the political branch has been thinking about diversity, right? As we know, I know there's a recent bill on gender in India, and there's a lot of problems with that as well. But many ways that there has been political discussions about how we give more positions of power to women in traditionally oppressed castes, but that conversation had, we're not really necessarily seeing that output at the court in a particularly a large or significant way. So with those points, I'll turn it over to William.
And thank you, especially to the Center for Asian Legal Studies. Thank you, Raeesa. Thank you, Christian. And thank you to our commentators as well for this wonderful opportunity and discussion. I do want to kind of continue the theme of contradictions and maybe the idea that the court, despite its tremendous stature, its immense popularity, and its sweeping power with respect to what is the world's largest country now. I think it's officially the world's most populous country. There is a sense in which, in many respects, the court is working at cross purposes with itself. And so I'm going to just identify a couple additional ways in which that manifests itself in the data that we've looked at. One of the things that the court really takes pride in, and is a part of the way that the justices of the Supreme Court describe their own role, is that the court is a people's court. The court is a court that provides access to justice, and in particular, access to justice to the common person, even to the downtrodden and the disadvantaged. And a question that we want to ask when we look at the data in order to examine whether the court lives up to this aspiration to be a people's court is, what does it mean to give access to justice to the common person? The court definitely hears lots and lots of cases. That's very clear in the data to anyone who wants to look at it. The court today receives maybe 60,000 or more appeals and petitions every year. That's an enormous caseload for any court, certainly for a Supreme Court. And this is a caseload that, to talk about trends over time, this is a caseload that has grown dramatically over time. 40 years ago, the caseload was 1/3 of that size. But there's a trade-off here because, as the old saying goes, justice delayed is justice denied. And one concern that we might have is that a high volume of cases can induce court congestion and long delays. And when we looked at the data, that is exactly what we find. In the Supreme Court, something approaching 40% of all cases pending in the Supreme Court have been pending for more than 5 years. And on top of that, an additional 7 or 8% of cases have been pending for more than 10 years. So there's an enormous amount of delay among cases that are pending before the Supreme Court. One concern, therefore, is that a court that is so willing to admit cases for hearings then is not successful at actually providing the hearings and providing the judgments that the litigants who go to court are seeking. Another concern about access to justice is that because there are so many cases coming into the court, most of these are so-called special leave petitions, or SLPs, in which the court has discretion to hear the case or not hear the case. After an initial hearing, the court can admit it for a further hearing or deny the petition outright. With so many petitions coming in, the court nonetheless attempts to give an individualized, in-person oral hearing to every single case. How can a court give individual hearings to 60,000 or more cases per year? Well, the answer is quite simple. The hearings are extremely short. And by extremely short, as we talk about in the book in several places, the data that we cite from other very excellent studies that have looked at this is the typical hearing of a special leave petition lasts less than 2 minutes, about 1.5 minutes, or 93 seconds to be precise. These are extremely short hearings. And so although there is access to justice in the sense that a hearing occurs, it's an extremely brief hearing. And one of the things that I'm going to talk about in a moment is that one of the consequences of hearings being so brief is that the substance of the legal claims that someone might bring, there's simply no time to address the substance. And so other factors that may have a lot less to do with the legal merits and a lot more to do with perhaps the how prestigious the lawyer representing the party is, might end up deciding whether a case gets heard or not heard. How can we address a situation where a court is receiving tens of thousands of petitions every year, giving them maybe 1 or 2 minutes worth of hearing, and thousands of cases remain backlogged for years, 5 years or 10 years or more? There are various proposals that we offer in the book for ways that the Supreme Court could begin to reimagine its role as a people's court, as a court for the common person. And I'll just mention 2 of them now, and we can talk more about them perhaps later. One is the court could focus less on simply hearing a lot of cases and more on hearing fewer cases, but attempting to address questions that are of great importance to a larger number of people. And following a model where there are fewer hearings, the court gives hearings to a smaller number of special leave petitions, but it focuses on those special leave petitions that might answer important questions that will do justice not just to the people who are before the Supreme Court, 10,000, 20,000, 60,000, but to the literally tens of millions of parties who have cases pending before the district courts and the high courts of India. There's more than 30 million cases pending throughout the courts of India. And so no matter how many cases the Supreme Court takes in its own docket, it can never touch more than a tiny, tiny fraction of all the cases in India. So what access to justice means, in our view, for the litigants who are in the Indian court system, it's not necessarily a chance to be heard by the Supreme Court for 93 seconds. It's a chance for the Supreme Court to rule on legal issues that will allow the courts that they do have access to, district courts and high courts, to reach rulings that reflect a more just approach to the law. The other possible reform that we mention in our book, in our discussion of backlogs, is reducing the reliance on oral hearings, not giving an oral hearing to every single case that comes before the court. And that brings us to the second thing that I want to mention very briefly, which is the role of senior advocates. Senior advocates represent the elite tier of the Indian bar. These are individuals who can charge 1 or 5 or 10 lakh in rupees for a single appearance in the Supreme Court. And a single appearance, mind you, that might last only 93 seconds. These are individuals who make up less than 1% of the bar, but they appear in something like 40% of all of the initial hearings before the Supreme Court. In other words, these are very high-priced, very influential, very powerful lawyers who have a role in a lot of litigation before the Supreme Court. The individuals who are named to the title of senior advocate by the Supreme Court are lawyers with years, usually decades, of experience in law, sometimes experience in politics and government as well. And what this means is that the senior advocates who argue cases before the judges of the Supreme Court will have more experience in the Supreme Court than the judges themselves that are hearing the cases. Now, why does this concern us? Well, when a hearing is only 93 seconds long, what kinds of clues is a judge going to use when making a choice between denying the petition entirely or allowing the petition to go forward and have a full hearing on the merits? That's not enough time for the facts of the case. That's not enough time for legal arguments to be fully explored. Instead, a court that's pressed for time is likely to rely on simple signals like, how experienced is the lawyer arguing before me? How prestigious is the lawyer before me? And our concern here is that, to return to where we began, the court is working at cross purposes with itself. It's a court that wants to be the court of the common person, a court of the downtrodden, a court of the disadvantaged. And yet, what we see in our data is senior advocates have much higher likelihood of the cases that they represent being admitted for a full hearing rather than being denied. But senior advocates are the most expensive lawyers in India. They're the least accessible lawyers in India. And yet they are the ones who are the gatekeepers to a case getting heard on the merits rather than being denied at an initial hearing. Our suggestion then, just to return to the suggestions that I mentioned before, is if the court reduces reliance on oral hearings and emphasizes a focus on the legal issues in a case rather than individualized hearings for every single case that comes before it, this will shift the focus of senior advocates' advocacy before the Supreme Court from relying on their influence and star power, so to speak, but instead using their legal expertise to allow the court to serve its mission of improving the law, the common law, the legal interpretation, the constitutional interpretation of the law, and to give justice to more of the people of India in that way. So I've gone on for long enough. I'll now turn things over to Aparna, and thank you all for this opportunity to speak.
Thank you, William. I'm going to jump right in. Another issue that we discuss in the book, and this is something that India has in common with many other South Asian jurisdictions, was most recently an issue in Pakistan, is the powers of the Chief Justice. So as the size and complexity of the court has increased, so has the role of the Chief Justice in administering the court. And as we discuss in the book, this administrative power can be used and is used to impact judicial outcomes on the judicial side. So the main administrative power that we discuss is the Chief Justice of India's master of the roster power. This essentially means, this power means that the Chief Justice of India controls the docket, and they decide which judge will hear what matter and when. Now, in 1950, when the court was set up, this power did not amount to much. There were only about 8 seats on the court. Judges often sat en banc or in large panels. They also had much fewer cases to split between the judges. However, over time, and this is again one of these issues where time trends have diverted from the original design of the court. Over time, the caseload of the court has grown. Parliament has responded by increasing the number of judges on the court to a point where now we have 34 seats on the court. They get about 60,000 petitions each year, and to decide these cases, the court sits in small benches, mostly in benches of 2, sometimes 3 judges. The Chief Justice sets up these benches and allocates subjects to these benches, and then the registry of the court auto-assigns cases to each bench, depending on the subject matter. So far, so good. The problem arises when the Chief Justice has to set up a special bench to hear a particular matter. Now, this can happen because there's conflicting precedent on a point that needs to be resolved by a larger bench, or because the case involves an important constitutional issue and the Constitution itself requires that at least 5 judges should hear these matters. These benches are called constitution benches, and I'll be using this short form going forward. So in these cases, the CJI sets up a special bench and allots a specific case to that bench. So one of the key findings of the book is that the Chief Justice uses these administrative powers to set up constitution benches and allot cases to them with an eye on the outcome of the case. We find, for example, that Chief Justices over-assign themselves to constitution benches. So the CJI, the Chief Justice of India, is present on constitution benches around 88% of the time, which is 4 times more than the next senior-most judge. Seniority or any other discoverable impartial standard is not the basis of case assignment. This is something that we study and find in our work. The only discernible factor that we could find that influences the constitution of a bench is that the Chief Justice is rarely, if ever, in a minority in the eventual judgment. So in our data set, the Chief Justice was never in a minority. And as on date, studies have shown that in the thousands of constitution bench decisions that the court has delivered since 1950, the Chief Justice of India has been in a minority only 13 times. And that is not consistent with the rates of dissent on constitution benches. As we can imagine, these are the most contentious issues and they see a high rate of dissent. But the Chief Justice of India has the unique ability that no other judge has of always carrying the majority with them. So in sum, the Chief Justice of India is oversigning cases to themselves giving themselves an outsized role in very important political and legal controversies of the day, and they constitute benches in a way that they can always carry the majority with them, a feat that no other judge can equal. And we take these to mean that the Chief Justice of India, therefore, using his administrative powers, can and does influence judicial outcomes. Now, another element of the master of the roster power is that the Chief Justice of India has to set up the bench in the first place. And increasingly, we are seeing that CJIs have the tendency to not set up benches on time so as to evade deciding sensitive cases and effectively to decide by not deciding. So to just take one example amongst many, many such examples, a challenge to some rather remarkable amendments to India's campaign finance laws, which was filed in the challenge was filed in 2017, was finally heard last month. And in the meantime, we've had one national election, many state elections. We're due for another national election in the next few months. And we've had all of these elections under these rules that strongly favor the government in power. But Chief Justices in the past have just not set up these benches to decide this case. So that's another way in which the Chief Justice uses the master of the roster power to impact outcomes by the simple expedient of not setting up benches in the first place. And if asked to justify why important matters are not being heard, judges of the court will hide behind the large docket that the court has and say that they just do not have the time to spare enough judges to decide these big matters. And that's true. That's true to an extent. William has already talked about the backlog and delays that the court faces. And a large part of that is because of the appellate power, the appellate side of the court's jurisdiction, which again, as William has mentioned, is the other significant transformation over time, where the court was seen mostly as a constitutional court with the tag-along appellate power that is now transformed into a court which is primarily an appellate court with a somewhat of a tag-along constitutional power, because today 90% of the cases on the court's docket are appeals from lower courts. And the court has consistently refused to set clear guidelines on which cases it will admit under this discretionary appellate power, leading to all the problems that William has already mentioned with respect to all cases getting appealed to the Supreme Court not having enough time to hear these cases, increasing the the instability of precedent in the system, and increasing the power of senior advocates. So I'm not going to discuss that anymore. I will just say that overall, therefore, the theme of the book is that the court of today is very different from the court of 1950 in its structure, in its functioning, as well as in the demands on its time. This transformation has been driven by a very conscious change in the role of the court, and that judges of the court very intentionally embraced in the late 1970s to make the court more open, more accessible, more people-oriented. However, the institutional and administrative processes of the court are working at cross purposes with this role, a theme that Sital has elaborated on. And in our book, we advocate for ways to align the role expectations of the court and its processes and functioning. Our large takeaway is that we need a more accountable court, accountable to clearly enunciated standards against which the functioning of the court can be measured. So that's the big takeaway from the book, but happy to discuss the takeaways of the book and our specific policy suggestions a bit more in conversation with the other panelists and during Q&A. Thank you so much.
Thank you so much, Aparna, Sital, and William. These are wonderful comments. They really enhance the reading of the book. Dr. Sen, please go ahead. Yeah, thank you.
Thanks, Raeesa, and thanks to the organizers for having me here. I might perhaps be the only non-lawyer or strictly legal studies scholars on the roundtable. Hence, I'll keep my remarks brief in the interest of letting the real experts speak, and also for having more time for discussion. Before touching on some of the issues raised in the book, let me first say that although the book is relatively slim, it more than makes up for that in the fascinating data presented and the deep and often counterintuitive insights into the functioning of the Indian Supreme Court, sometimes characterized as the most powerful court in the world and one that exercises jurisdiction over 1.3 billion plus people. Some of these have already been outlined by the authors. I'm sure the other panelists will touch on different aspects of the book. So let me focus on a couple of issues raised by the author, which broadly deal with the intersection of the Supreme Court and its judges with politics and the influence of the other branches of government on the judiciary and judicial independence. I do so partly because of my own interests as a political scientist and analyst, as well as the lack of public knowledge, at least in India, about Supreme Court judges. The latter, of course, has something to do with the short tenure as well as the large number of judges on the court, which Sital mentioned, which stands at 34 currently, as compared to, say, the Supreme Court in the United States, which is, of course, much smaller and where judges are appointed for life. And I dare say, sometimes some of them cling on to the position much longer than they ideally should. As the authors of the book show, on average in India, Supreme Court judges with a retirement age of 65 years have had term limits, and this is something again that Sital mentioned, of less than 5 years in the contemporary period, with the Chief Justices, again in that same period, having an average tenure of roughly 9 months. The early retirement age and short tenures have raised a host of issues, some of which Sital outlined, including Supreme Court judges seeking employment after their retirement. Since they're prohibited to return to private practice at the Constitution, many of them end up in the employment of the government. Since, as the authors show in another section, that the government is by far the biggest litigant before the court, there are many judges who, in fact, pander to the government in the hope of post-retirement benefits, and a quid pro quo often develops. Indeed, we recently witnessed a somewhat unusual spectacle of a Chief Justice of India being nominated by the government to the upper house of Parliament, or the Rajya Sabha, within weeks of his retirement. While there are a few studies documenting this phenomenon, what is perhaps more difficult to identify and study is the ideology of judges and whether they are prone to lean a certain way, especially on constitutional and other matters. I have an interest on this issue, having tried to flesh out the ideology and worldview of a prominent judge from the 1950s and 60s in relation mainly to religion and secularism. And the name of the judge was P.B. Gajendra Gatkar, who was on the Supreme Court from the 50s and was also a Chief Justice for a little over 2 years between 1964 and 66, and left a fairly large corpus of speeches, writings, and correspondence. This issue has become more important now that we have a government in India over the past decade or so, which espouses a very definite ideology and orientation. I would perhaps like to hear what the authors might have to say on this. More generally, I'm also interested in what kind of role the Supreme Court is playing in what some term as the democratic backsliding that is happening in India, and of course in many other parts of the world. Many of us at this roundtable, of course, are aware of the role that the Supreme Court and the courts in general played in facilitating the emergence in India between 1975 and 77. Currently, a disturbing element of the court's role is what a legal scholar has called judicial evasion. Among the critical matters that the court has repeatedly postponed hearing were the repeal of Article 370 of the Indian Constitution, which gave a special status to Jammu and Kashmir, challenges to the Citizen Amendment Act, or the CAA, and the electoral bonds issue, which Aparna just mentioned. Some of these, of course, have now been taken up, but the progress has been very slow. And as Aparna mentioned, for the electoral bonds issue, we have already had one general elections in 2019, and we have another one coming up early next year, but the issue has not yet been decided. This judicial evasion and lack of clarity has also been very visible in various habeas corpus petitions before the Supreme Court and other courts. The authors of the book note a 2013 ruling where bail was not granted to an opposition politician on the basis of the magnitude of the case, and this, I'm quoting the the Supreme Court, and the investigating agency's request, but it did not discuss any substantive law or cite any precedent. Indeed, one of the more worrying aspects of the Supreme Court over the last decade is the abdication of its role in defending personal liberties and freedom, and the selectivity with which civil liberty cases are taken up. For instance, in 2020, the court moved speedily to secure the bail in a case of abetment to suicide of a television anchor known for its pro-government views. This was in contrast to cases related to several civil rights and political activists, some of them elderly and ill, who have been in jail for over 2 years at the time. While granting bail to the news anchor, then Justice D.Y. Chandra, who's of course the CJI now, had said, I'm quoting him, if constitutional courts don't protect liberty, who will? Close quotes. In response, legal scholars as well as practicing lawyers have noted that while bail was justified for the TV anchor, it also highlighted the plight of those who had been denied their rights. Many of the detentions since 2014 have been done under the Stringent Unlawful Activities Prevention Act, or UAPA. According to a former High Court Judge, A.P. Shah, the Supreme Court has effectively created a new doctrine where, and I'm quoting in, accused must remain in custody through the period of a trial, even if evidence against the person is eventually proven inadmissible. He believes that the effect is similar to the preventive detention laws of the emergency, where courts deprived people access to judicial remedy. Perhaps one of the most glaring examples was that of octogenarian Jesuit priest and tribal rights activist Stan Swami, who was suffering from Parkinson's syndrome and other ailments, who had been arrested in 2020, kept in custody under the UAPA. After a special National Investigation Agency, or NIA, court rejected his bail application, the Supreme Court refused to intervene, eliciting strong criticism from civil activists, rights, and lawyers. He was moved to a hospital in 2021, only after the Bombay High Court intervened, where he died. On that somewhat grim note, let me hand the floor over to Raeesa. Thank you.
So much, Dr. Sen, for those great remarks. Dinesha versus Samararatne, we can have your comments next.
Yeah. Okay. Thanks. So let me also begin by adding my congratulations to Aparna, Professor Sital, Kalantry, and Professor William Hubbard for the publication of this book. Speaking from a South Asian perspective, I think this book has the potential to be a turning point in how we study courts in general, but more specifically in jurisdictions that are broadly understood to be in the global South, such as India's neighboring jurisdictions, including Sri Lanka. And my thanks to the Center for Asian Legal Studies for inviting me to be part of this conversation and for giving me the opportunity to engage with this remarkable book. So in the next few minutes, I will make 5 points in response to what I think are some of the key interventions in this book. There's a lot to be said about this book, really, and I look forward to following the conversation as it develops around this book. First, I'm hoping to situate the book in relation to 3 other books. Placed in conversation with these 3 books and the approaches to the study of the judiciary reflected in those books, I think we can better appreciate the impact that court on trial will have in how we think not just about the Indian Supreme Court, but also about how we should think about other superior courts in the global South and perhaps more broadly. Second, I will respond specifically to some of the key questions that the authors ask in this book and briefly explore the broad implications of the very framing of those questions. Third, I'm sorry about the background noise here. Third, I will comment briefly on why I think this is a long overdue and essential departure from the dominant way in which we have studied courts in common law jurisdictions. Fourth, and relatedly, I will offer some reflections broadly on methods. I think this academic intervention can set benchmarks in 2 ways. One is to mainstream data-driven evidence as an important and perhaps even essential measurement of the work of courts. and two, to challenge scholars such as myself in this field to engage more with empirical data of the type that is examined in this book. Fourth and finally, I would like to comment on how this book contributes to the debate on access to justice as a human right. So how do I situate this book? Four books come to mind, really. One is, of course, Anuj Bhuwania's book, Quote in the People, in which he offers a strong critique of public interpretation in India, which was a corrective to the romanticization of the work of the Indian Supreme Court, particularly in relation to PIL. The second, going back in time, is the edited volume by Sunil Kirnani, Vikram Raghavan, and Arun Thiruvengadam, titled Comparative Constitutionalism in South Asia, which of course aimed to offer insights not only to the study of courts, but more broadly to the state of constitutionalism in South Asia. Now, in that book, Arun revisits an older work edited by Neelam Tiruchelvam and Radhika Kumaraswamy titled Judiciary in Plural Societies, published in the 80s, which offers a comparative assessment of select jurisdictions from Asia and Africa on the question of the role of the judiciary in plural societies. And the other book I want to add to this mix is the work by the legal historian Paul Halliday, Habeas Corpus from England to Empire, published in 2010, which examines the work of superior courts in the British Empire from a historical perspective. Now, there is much to be said about the synergies between these different works. In the interest of time, I will only say this. These different bodies of scholarship taken together makes us acutely aware of the broader context within which the work of any course must be interpreted. That could be historical, political organization, whether empire, state, or region, lived experiences, pluralism, ethnic conflict, and development of legal doctrine. There are, of course, other factors, and I'm only naming a few here. But court on trial is an important addition to this conversation in that it brings in numbers and a data-driven approach. The moment we do that, the questions we ask necessarily change. And the potential for asking new questions emerge, and we are once again made alive to the exciting possibilities for developing new methods and therefore also new knowledge. So really, I thank the authors for offering us those possibilities through this remarkable book. So turning to my second point, why do I think this book is a welcome departure from business as usual? So for people like myself who were inducted into the study of courts through the common law method of judicial precedent, the emphasis is, of course, on judicial review and judicial reasoning. The dominant conversation is about the development of doctrine. But as many of us on this call would know, the lived experiences of and in superior courts involve much more. So this book is really a guide in how we can concern ourselves not just with judicial precedent, but to locate judicial precedent in that broader canvas. As the authors rightly note, what happens in that broader canvas matters for a whole range of reasons. First, of course, revealing that canvas is our obligation as scholars. And I think the authors have done a really beautiful job of revealing that canvas to us in the case of the Indian Supreme Court. But beyond that, what happens in that broader canvas is intimately tied up with how judicial precedent is developed or not. And again, the authors do that work to show us how those connections exist and why they matter. So to that extent, I think all three of you have challenged all of us to take more seriously the day-to-day work of a court and to take account of the big picture from the perspective of those lived experiences. Turning to the key questions and the implications, as I've already mentioned, we have asked for a long time the question, what ought to be the role of a court? This is, of course, a central question, and many answers have been developed over time in response. Court on Trial asks a different question. What role, in this case of the Indian Supreme Court, has it been actually playing? And the answers presented make us pause. And as Professor Hubbard demonstrated us, it's a story of contradictions. We assume the court to play a particular role, but you look at what actually happens, and then you see that a different story or different explanation emerges. So the answers, in that sense, challenge us to rethink the weight we attach to judicial precedent. How we think about the legal profession vis-a-vis access to justice, and also about unintended outcomes, even of the best intentions that a court might have. In this way, Court on Trial has expanded the space in which we can continue to ask both questions in a mutually beneficial way. The questions being, what role has the court actually been playing, and what ought to be the role of the court? I have only 2 more minutes, so I'll keep my last 2 points very brief. So on methods, very briefly, I'm not even a novice when it comes to data crunching, but what I want to say is the following, that this book does a very impressive job of bringing the normative, the descriptive, the empirical, and the analytical together without overwhelming a reader who may identify with any one of those traditions, and affirm that really the clearer picture is to be obtained when we come at these questions from multiple methods, provided we have the expertise, etc. And the 5th point I want to make is on access to justice. Access to justice is now recognized as a human right. But this work tells us that if we think about access to justice as a human right, the work that goes into strengthening access to justice cannot be limited to digitizing court registries, setting up specialized courts, strengthening alternative dispute resolutions, etc. We are all familiar with certain kinds of agendas that come in with access to justice initiatives. This work reminds us that access to justice has a substantive component which has to be understood and interpreted, and there is much more work to be done in that area. So to conclude, a well-written academic piece makes us think and also makes us see the world differently. And Court on Trial does both. I loved reading it. We don't have time to discuss this point, but as somebody else also already mentioned, it's one of the most accessible books I've read more recently. So I want to thank the authors for communicating so clearly and effectively the insights that you have drawn from such a complicated process of empirical research. Congratulations again, and thank you.
Thank you for those very detailed and thought-provoking remarks. Professor Khan, we can have your comments next.
Thank you for having me here, and I also want to thank the authors because I had an absolutely wonderful time reading this particular book. So I'll get into sort of the meat of it, but I think in terms of sort of bringing together the conversation in terms of what the author spoke about and what the other discussants talked about, this book covers a lot of themes in a very succinct way. And I personally found that there was a lot of similarity between how the Indian Supreme Court and the Pakistani Supreme Court function. And I've been working on the Pakistani Supreme Court and sort of bucking Aparna for my feminist judgments project also. So I think, so that sort of similarity aside, this theme, the sort of the themes that are covered, it's not just evaluating, how effective the court is from one particular angle. So much of the writings that we generally tend to find is like, oh, how effective is public interest litigation, or how effective is the appellate jurisdiction, or what is the case backlog seems like, because of course across the Indian subcontinent what we do see is a very large population, and then that inherently adds a very huge burden on our courts, right? So even when we sort of bring this discussion in the domain of Pakistan about case backlogs, one of the things that we tend to hear is like, oh, our population is so large, so of course the court is going to be overwhelmed. But this book presents a very nice overview about the various domains through which cases are entering the judicial stream, who's bringing those cases. So So, and then largely touching upon again things that you've all mentioned, so I'll sort of glance through them. The notion of access to justice, right? So the rhetoric of the Indian Supreme Court being a people's court, that's also something that I find very similar across the two jurisdictions, although possibly for different reasons. So in addition to our shared history between Pakistan and India in terms of how we had the same federal court that split in 1947, and then of course the judicial structure emerged into high courts and having a Supreme Court. But this notion of the Supreme Court in both territories going by calling itself a people's court or the guarantor of rights and protection of the marginalized and oppressed, that's also a very common sort of a notion that we find. And the reasons or the way that's being done, of course, that was quite intriguing for me. And when you're looking at that, so my understanding, of course, and then that's sort of been clarified in the book as well, is that this notion that the court is not just providing you an arbitration forum, but is going to be there to protect the weak parties, that this is just the protection of that sort of rhetoric is one of the main contributing factors to the case backlogs, right? So in India, it's through the excessive number of SLPs that are being heard, even if they are not being admitted later on for a full trial. And in Pakistan, we sort of see that similar mechanism happening through the way primarily of original jurisdiction of the court under Article 184.3, and then of course the excessive use of suo motu powers. And that excessive admission or excessive time that's spent on these issues ends up essentially causing delayed justice or denied justice, and as sort of Professor Hubbard was also talking about. And another interesting thing essentially that I see is, of course, and that's something Dinesha has also talked about, is the development of precedent or lack thereof that's been highlighted in the book. So the idea that in a lot of cases, the court essentially, or the judgment pertains primarily to reviewing facts of the case and just simply deciding on that, as opposed to, I mean, they will of course mention like what laws are being applied, but how those laws are being applied, what test is being derived. Those are things that again missing in many of the very fundamental judgments as well, sort of what could have been landmark judgments but are not. And then and coming from the common law tradition, we essentially fail in understanding what the test is and how the precedent is even developing, because it's essentially all a discussion about questions of fact as opposed to questions of law. And that again is another sort of a frustration that we have been experiencing on the Pakistani side of the border as well. And then, of course, another notion that's already been discussed, so I'll go over it very quickly, is about judicial evasion, which Dr. Sen talked about, but I also like to take it a step further and take it to the idea or notion of clash of institutions. Because one of the things that the book highlights very effectively is the progression of the judges' cases, and how the Supreme Court in India went all the way up to challenging and contesting a constitutional amendment simply in order to protect or retain the judicial appointment powers within the collegium. And the collegium, of course, is to my understanding, being headed by the Chief Justice of India, very similar to how in 2010, when the 18th Amendment changed the judicial appointment procedure in Pakistan and created a judicial commission and a parliamentary committee, the Chief Justice then took a suo motu, accepted petitions against the 18th Amendment on the pretext of protection of judicial independence and retaining the judicial appointment powers within the domain of the judiciary itself. The idea that any political intervention or any contribution from other branches of the state was essentially unwelcome, which is also quite disconcerting, because again, another question that one must ponder upon is who ends up becoming a judge. So I think the book does a fantastic job of telling us what happens once a case does go to court, and the undue influence or the excessive influence, perhaps, of senior advocates who are otherwise quite inaccessible, right? So if you are pandering to as the court, you're pandering to senior advocates, that essentially automatically means you're taking away from not just junior advocates, but also from people who cannot afford to hire such expensive lawyers. And that essentially, again, sort of challenges whether the court is actively, effectively providing justice to the parties who are approaching the court in itself. But this clash of institutions, I think, is also something that I found very, very interesting, where the Supreme Court directly attacks, using the basic structure doctrine, the parliament and its constituent capacity. And we've seen how the Supreme Court has on other occasions erred away from such direct interventions. And that, I think, is something that was truly interesting for me. I would also essentially, I think one question that I sort of had, and perhaps the author, maybe I missed it, but the authors could clarify. So when the Supreme Court size changed from 8 to 34 judges, you all mentioned in the book how, and also in the presentation, how there was a usage of smaller benches, particularly 2-member benches, is very common. And that essentially just made me question about what happens about dissent, right? So we know that the Chief Justice is the master of the roster, and the Chief Justice is rarely in minority, if ever, on the benches that he himself is part of. But is this a question of, creating the other benches or the power of creating the other benches also another reason why 2-member benches are possible? Because the Chief Justice is doing an exercising and making sure that there is some form of consistency between what the judges are saying, because in case there's a disagreement or dissent, what would be the outcome of that? So that essentially is something that was quite intriguing. Another thing essentially in terms of judicial appointments, sorry, I sort of should have mentioned earlier, is also the issue of lack of transparency, right? So in terms of how the collegium actually functions, I was hoping to learn a little more on how public or lack thereof are the proceedings of the collegium itself, because even that and that's something that's been a source of contention in Pakistan as well, and that often directly sort of addresses or begs questions in terms of the issue of diversity, and how you mentioned, and I think that's a very, very important question to ask, that simply having regional and religious diversity, which again are things that we've sort of inherited from our colonial past, are still somewhat recognized. But in terms of having or promoting gender diversity, focusing on various other castes, or even focusing on disability, I'm not sure about how or if any disabled judges have made it all the way up to the high courts or Supreme Court. But those things essentially are directly affected by, in terms of what is actually going on in the discussions of the collegium, and how the initial, or if there are any metrics for the initial nominations that the collegium comes up with, which are then subsequently deliberated upon. And so just to sum it up, I think, again, absolutely wonderful book, and I really enjoyed it, and I think it should be a mandatory reading in Pakistan as well. And there's absolutely so many similarities, starting from very basic things like retirement ages at the High Court and Supreme Court, which are exactly the same in terms of how, despite the varying history and despite the long history of Pakistan's dictatorial regimes, both Supreme Courts are very sort of protective of retaining judicial appointment powers. And then, of course, the idea of whether or not the court is actually a people's court. And I think the statistical analysis that the book delves into, and I think so something Dinesha mentioned as well, there's a lot of data that's been condensed into and presented in a very easy to read and understand form, especially for people who are challenged with maths like me. So it's a very, very accessible book. And thank you so much for doing this absolutely wonderful job. I think it was a much, much needed venture.
Fantastic comments. We're going to open the webinar for Q&A. So if you're participating, please drop your question into the Q&A box, and I'll read it out for the panel. As we're waiting for questions to be raised, I just wanted to check in with our authors and see if you'd like to briefly respond to some of the comments that we've had from our panelists. If you'd like to, please go ahead.
So I can just start and say thank you really so much for the very observant and exciting comments for us. It's always wonderful to have people engaged with it, and I've learned so much from your own comments of the similarities, for example, with Pakistan and the way you look at it, Dr. Roy, from the political branch's perspective, and of course from Dr. Samararatne. I really enjoyed your observations. The one point, kind of larger point that I just wanted to make was to say, of course, our method is to look at the forest, right, and not the individual trees. So we can't really say anything necessarily about what individual judges have done or what their individual views have been. And as you say, Dr. Sen, it's obviously hard to do that when they are on the court for such a short period of time, and when they honestly, this goes to Professor Khan's point, they're only adjudicating run-of-the-mill cases. So when they're sitting in these two-bench courts, two-judge benches, they're not adjudicating cases that have precedent or that are setting precedent. They're just, almost like trial courts. So in that sense, we can't even know what their political views are because they don't have the ability, they don't show it. But more precisely, right, we're not looking at cases, we can only see trends. We can't see the trees, we can see the forest. And that is also gives us a tool that I think, as many of you observed, right, hasn't been brought to the table in understanding courts and in South Asia and particularly in India. So that was my kind of brief observation overall, and I'll turn it over to Aparna and William.
Thanks, thanks, Sital. Again, thanks so much for those generous comments. It's really heartening to see that something that we found very challenging has paid off, which is, as academics, how do we condense our writing and how do we write in a way that is accessible to a general audience? Because one of the motivations for writing this book and publishing with Penguin as opposed to a more traditional academic publisher was really for this book to become part of the general conversation around the court beyond the legal circles. And it's good to know that, that effort has paid off. That's, I think, the biggest challenge that we faced in the writing process, because it went against our own training as academics to write as densely as possible. On Ronojoy, on your question on ideology, yes, we haven't been able to track that. I think one additional reason beyond the ones that Sital mentioned is also that the political culture in India, as you know better than I do, doesn't really track very well onto established ideological patterns. So it's very common to see judges who are politically or socially conservative but economically liberal, and vice versa. And so with this short tenure, when they're mostly deciding cases that are on the facts of the case, it's hard to track ideology. What we've done is looked almost at court metadata rather than on the actual reasoning that the courts have provided. And, Marva will tell you through our feminist judgment projects that we've been in conversation with, we've realized that, of course, ideology is something that is to be explored through the reasoning that courts adopt more than just the outcomes of cases. So that's one reason why we've not tracked, and it's been difficult for us to track. I completely agree with you that the Indian courts have been part of the process of democratic backsliding, to put it mildly, in India. And I think, and the point that we're making in the book is that that's very much a function, it's as much a function of the structure of the court that allows for it to be captured so easily as and I should say this is my personal view. I don't want to post this on my co-authors, but my personal view is that it's the structure of the court that allows for it to be captured so easily, and allows the court to evade its responsibility in deciding cases, as much as it is a function of ideology, that ideology can find the space to use the Supreme Court's power to legitimate government power rather than question it. because of the structure of the court, and that's the story that we're trying to say. Very quickly, Marva, two-judge benches are, there's a cultural norm in India, and I wonder to what extent it resonates in the legal culture in Pakistan, where judges generally follow seniority and hierarchy. And two-judge benches are generally composed with a senior judge and a junior, relatively junior judge, means a more recent appointee, and typically the junior judge will defer to the senior judge. Dissents are uncommon across the board, but when they do happen, a three-judge bench has to be set up. It leads to additional proceedings, and there have been calls to abolish two-judge benches, but that hasn't happened. Finally, on collegium proceedings, they are not transparent at all. There was an attempt a few years ago to increase transparency and to put out detailed notes on the conversations that happened within the collegium, but that led to all sorts of unintended consequences of all kinds of things being said about people who had no way to respond. And so the court has now gone back, the collegium has now gone back to having these sort of almost template kind of responses to say we are appointing such and such person because we find that their past experience, their practice, so on and so forth, and their seniority meets our standards, something along those lines, right? Which really doesn't tell you very much. So that's collegium resolutions are in the public domain, but essentially it's a one-line or a two-line resolution. It doesn't really tell you much. I'll stop here and see if William has anything to add.
I'll just echo the gratitude for our commentators today. Thank you so much for your comments and for your reflections. I did learn a lot, especially about the larger context in which this book appears. And I think it is very important to understand that it's in conversation with work that is doctrinal in nature, that looks at doctrine, history, lived experience, political context, and so on. I think that the quantitative data that we bring to bear in this book is an important missing component of that larger conversation that helps us understand the court by triangulating, if you will, among all of these different ways of gaining insight into the court. Thank you so much for your very generous comments. And I think it looks like there may be some questions coming in the Q&A. So I'll step back so that we have a chance to hear some of those.
We have two questions in the Q&A. I'll read them out and then you can have a chance to respond. So Mario Gomez, an old friend of Cal's, is asking, did the authors uncover any interesting findings on gender? For example, did women judges decide differently to male judges, either as part of a majority or in dissenting opinions? And then from Mariam Khan, she says, thank you for this excellent panel. She'll definitely get the book. Her question is that it's clear that the Chief Justice has tremendous power in influencing outcomes on constitution benches, but can you say what goals or interests this power and influence is oriented towards? Are there any trends that show whether the Chief Justice aligns with the political incumbent of the day? Or to put it another way, to what extent do you see the Chief Justice and his allies on the court dissenting from the prevailing power structures, even as he may be swaying the bench in question? So you can respond, and then if there's time, maybe I'll abuse my moderator privileges and add another question.
So I can address the first question. So to be honest, we didn't actually code for specifically gender and outcomes. I mean, in fact, we didn't really code for outcomes at all. But more importantly, even had we, I think the size, the sample size would have been so small that it wouldn't have revealed anything. There have been so few women on the court, maybe in the single or low double digits over 50 years. It's only now that maybe there's the most that's ever had, right? Which is whatever, 3 out of 34. So that would have been a great job. And as we, I think, mentioned, we weren't looking necessarily at the findings or the holdings, the studying the doctrine. So unfortunately, I think it would be interesting to do. But generally, those kinds of studies, I've liked those studies. I've cited those studies in my classes where in the U.S. context, right, where you find in the circuit courts where there are panels of 3, and where if there's a woman on the bench, it's more likely that to rule in favor of sex discrimination cases when there's not, or similarly with race. So those I love that kind of work, but I just don't think we could find it here, given that there's just not enough of these meaty type cases, and not enough women. Even if we, as Dr. Sen wants us to look at specific judges regardless of gender, I think it would be hard to do it in this kind of court where there are 34 judges deciding 5,000 cases, annually, and not, yeah. So I think I've made my point.
Yeah, I'll just add that I think there's only so much we can do when as Sital said, the sample size, so to speak, that we're dealing with is so small in terms of the total number of female justices. We do have a book chapter called The Supreme Court of India, an empirical overview of the institution, that provides some statistics on the rates of dissent, the rates of concurrences, the rates at which different individual justices authored opinions. We didn't break it down by gender, but one could certainly do that. You can just look at the tables and kind of count up the relatively small number of women where they stand on in terms of the opinion writing. One of the things that we did find in that study, which didn't make it into the book, there's just too many numbers out there to make into the book. We weren't able to do things like code for outcome, as we've discussed, but we were able to identify the fact that opinion writing duties, for example, were not kind of uniformly spread across justices. Some justices wrote a lot of opinions, and some justices wrote strikingly few opinions relative to the number of cases they sat on. With respect to dissents, because dissents are so incredibly rare, we just didn't want to draw any inferences about patterns at all, other than just the sheer fact that the dissent rate in the opinions that we analyzed was 0.2%. So 99.8% of cases had no dissent in it at all. I guess what I will say is the number one dissenter in our data in that study was G.S. Misra. So one of the female justices, if there is a dissenter, a great dissenter of the Indian Supreme Court, I suppose a female justice has that title. But just to put this in context, the number one dissenter in the sample period that we had for the Indian Supreme Court dissented 6 times. So 6 times out of out of thousands of cases. So just to put that in perspective, we really don't want to make any inferences about patterns based on gender or anything like that. But there are some interesting things that do come out of the data nonetheless.
I just want to say something that ties together the 2 questions, which is that, of course, outcomes cannot really also determine ideology or alignment, right? Because as again, this is going back to the feminist judgments projects, the reasoning is oftentimes more of a clue to ideology than the outcome itself. The outcome might be progressive, but based on very regressive reasoning. And we see that particularly, so that's not something that we've tracked. We've tracked only, in that sense, wins and losses. And when it comes to chief justices deciding, constitutional bench cases, one issue that we've had is that the case might have been filed against a law that a previous government had brought in, that the current government was championing, and then it's not very clear that the outcome necessarily supports one or the other political party in power. The second thing, obviously, goes back to the earlier point, that the outcome itself does not necessarily determine whether the government in power will actually thinks that the judgment is in their favor or against. And the classic example in the Indian context is, of course, the basic structure case, Keshwan and Bharati, where the court, in terms of its outcome, more or less upholds the law, the constitutional amendments that had been challenged, but obviously does so by at the same time, in its reasoning, bringing in the basic structure doctrine, which enraged the then Prime Minister so much that obviously, I mean, she then superseded the next few judges and interfered quite a bit in the working of the Supreme Court at that point. But if you look at it just in terms of the outcome of the case, in terms of who won and who lost, the government actually won the case in terms of getting the prayer that it wanted. So therefore to say that because we've not tracked reasoning, it's not very easy for us to say whether the CJI is using those powers in service of the government of the moment, or whether it's in service of their own ideology or something else entirely.
Thank you all. We have about 2 minutes left, and so I'm going to abuse my privileges as moderator and ask one more question. So this is just such a fascinating book, and as you can see, it's been well thumbed. The question that I have is that many of your recommendations directly seem to depend upon an impetus for institutional reform within the court. And this is slightly out of the ambit of your book, but I thought that maybe you could take the chance now to reflect perhaps on what it might take for that to happen. Because one of the comments that you've made earlier in this discussion is that the court has had, say, for example, opportunities to say frame guidelines for the admission of SLPs, and they've never taken up this challenge to actually do that reform. So are we waiting for a particularly charismatic Chief Justice to actually put these into force? Or do you see another pathway for the reforms that you're suggesting to take hold?
So just one, I did have this question for a former Chief Justice, and one of the things that they say is to reform is, well, it's Parliament needs to do it. I mean, I'm not specifically talking about the SLP, but general broader reforms, right? Oh, it's out of our hand. Of course, this was the same Chief Justice that rejected, under whose tenure the NGAC judgment was. So even when Parliament tries, that may be rejected and overturned, right? The amendment that tried to create a judicial commission for appointments. So I think there is that part of that, right? Some judges may feel this is too big for us, but and I don't know. I mean, I think Chandra is a brilliant Chief Justice. So if he would have, he's someone who could see the big picture and the larger vision, but I don't know why they're doing it or why they're not, and maybe Aparna has a greater insight.
So, I mean, just legally speaking, some of the changes that we are talking about are to the rules of the court, which of course the court has powers over, right? So the Constitution gives them the power to frame rules of the court. So things like the master of the roster power is through the rules of the court. So some of this is squarely within the judicial domain. The second thing, as you know, Raeesa, because literally you've written the most important chapter on that issue, is that courts in India are particularly jealous of their sort of independence, of protecting their independence, protected jealously, and for good reason. We've had, very significant encounters with the political branches in the past, which have caused them to be particularly concerned about that, which means that ultimately, regardless of which actor makes those changes, judges have to be convinced that there is a need for these changes, and this change is not going to impact the working of the judiciary. And so therefore, in some senses, our conversation is with judges, all right, as the insiders, as somehow, I think consciously or subconsciously, that's a conversation that we are having. But the reason why we wanted to, again, put this in an accessible form so that it performs public conversations is also that judges are not operating in a vacuum. They are also operating against a policy context where, people are talking about the court in particular ways, and the way in which the court has been talked about so far, and that might be changing now, but has generally been talked about, is that, the court will set us free. And here we are talking about the ways in which the structures of the court is really hampering the court's ability to live up to its best potential. And we are hoping that that kind of a public conversation also shifts the ball with respect to, judges who might not be really inclined to change, or even lawyers who might not be inclined to change, having to do so just because, the consensus around the court has been disrupted. So that's the grand ambition of the book.
Professor Hubbard, do you have any comments to add to conclude?
No, I'm happy to let Aparna have the last word substantively. Raeesa, I just want to thank you very much for moderating as well, and it's been a real pleasure.
I think that's our time. So on behalf of the Center for Asian Legal Studies, I'd like to thank you all for making the time to join us today for this virtual roundtable. I know I've learned a lot, and I hope our participants have enjoyed it greatly. And I'm sure that this book will be a part of academic conversations for a long time to come. So thank you all, and good morning and good evening to you.